Would you be pissed off if the advisor starts a business that's similar to yours? So you're a startup founder and you're thinking of hiring an advisor. What are the key issues you should look out for? In this video, we'll be doing two things. First, we'll be talking about the key issues that startup founders should be aware of before hiring your startup advisor. And number two, we are going to challenge ChatGPT to see what sort of advisor agreement it produces and whether it addresses the issues that we talked about. Let's introduce Mr. Advisor. He is your typical C-suite executive in a multinational corporation, perhaps an angel investor, and with experience in venture capital. Now, you want Mr. Advisor on your board of advisors because A, it looks good, B, because he has good connections and information and intel about the industry that you're working in, and C, because he's quite intelligent. Now, this is a relationship that you do not want to damage. But oftentimes and sometimes, relationships between advisors and founders can take a deep dive when certain things don't go well. The first problem that often arises is when the advisor is issued shares. What could go wrong? A, if the proper documentation is not entered into, the advisor could be transferring shares, mortgaging the shares, or having a loan on these shares without your knowledge. And when the founder finds out, he'd be pretty pissed. The second problem that we see sometimes is when the relationship between the founder and the advisor sours and the founder starts entering into its price round. The advisor then uses it as an opportunity to say, I'm not happy with the terms that's in a shareholders agreement, and therefore you guys cannot sign it until I agree. Now, that's an awful situation to be placed in as a founder. What other issues could arise? Now, let's talk about confidentiality and conflict of interest. Would you be pissed off if the advisor starts advising a competitor? Would you be pissed off if the advisor starts a business that's similar to yours? And would you be pissed off if the advisor starts telling other people what you do? If these things are gonna piss you off, you want to make sure that you have a document that says that they shouldn't be engaging in such a behavior, either without your consent or approval. The third broad category of issues that we see is mismatched expectations. As with all relationships, it's always good to calibrate what you expect from your advisor and what your advisor expects from you. But oftentimes we see disputes over things like, hey buddy, I thought I put in 20 hours of work and I thought that was enough for my 5% equity. And the founder goes, yeah, you put in 20 hours of work, but we were meant to use that 20 hours to achieve this milestone, which you did not help us achieve yet. And that's where the quarrel starts happening. In those circumstances, laying out clear milestones in which the advisor will be issued shares, such as whether is it performance milestones or time milestones, would be really helpful in preventing a disagreement with someone that you actually respect. Finally, the last thing you want your advisor whom you respect to do is to go public about any disagreements or unhappiness that you guys have between each other. Well, that can be addressed in a document by having a non-disparagement clause or having some sort of confidentiality provision. But if you don't put that in, he actually does not have an obligation not to badmouth you in public. So there are free advisor agreements available on websites. But before you use them, think about whether they cover these issues. For the purposes of today's video, we'll be challenging ChatGPT to see whether they address all the points that we spoke about in their advisor agreement. Let's check it out. So I'm going to ask ChatGPT, I am a founder. Please produce an advisor agreement for me. Smiley face. Let's see what they say. The first clause talks about duties and scope of work. It says the company agrees to engage the advisor to produce advice and consultation in the area of blank. An advisor agrees to be available to the company for consultation at mutually convenient times. Now, I'm a little bit uncomfortable with this provision because it's better to state upfront how many hours you expect the engagement to be, what is the form of engagement you require. For example, is it email, Zoom? Do you expect them to be on site? And just generally speaking, the scope and of work seems rather broad to me. It does not tell me specifically what you expect from the advisor. So I think this clause is too broad. It lacks specificity, and it's actually going to be great grounds for people to start fighting and disagreeing with things. The second clause talks about term and termination. It says this agreement will begin on X date and will end on N date unless terminated earlier as provided in this section. Either party may terminate this agreement upon X number of days of written notice to the other party. Now, this clause is not complete in my opinion, because as a founder, you want the ability to terminate the advisor agreement for cause. For example, if the advisor starts commencing a competitive business, or if the advisor starts playing dirty, you want the ability to terminate this agreement immediately. Why is that important for you? Let's say, for example, this advisor appears in the newspaper tomorrow as a money launderer, sex addict. You're gonna have to wait for 30 days before you can say that he is no longer your advisor, and that doesn't make sense at all. So that's where the protection comes in. The third one is on compensation. The clause reads, as consideration for the advisory services, the company agrees to grant advisor specific compensation details to be inserted. Now, this is the provision which I think people actually fight quite a fair bit on at a later stage, not when you're signing the document, but when they say like, hey, you're owing me things, and the person says, no, I don't owe you anything. The first thing is, if it's cash, it's more straightforward, because usually for cash compensation, you're tagging it to hourly rate, monthly rate, or per project basis kind of rate, which is more or less kind of clear. Where it becomes a bit tricky is when equity is issued. What we have found to help founders is when they're very specific in terms of if they can specify key KPI milestones or key performance milestones. Like, how are you going to objectify this performance and say that you have indeed performed? It could be in terms of, if you referred me 20 potential investors, that is one very objective way of gauging whether the advisor has contributed. That would reduce my business when it comes to dispute work, but prevent you some headaches. The next provision is on confidentiality. So the clause reads, advisor agrees not to disclose or use, either during or after the term of this agreement, any proprietary or confidential information of the company without the company's prior written permission, except to the extent necessary to perform services under this agreement. I like this clause because I sometimes see another variation of the clause which says that both parties need to keep information confidential. But for founders who are going through their fundraising process, there's a high chance they're going through due diligence, and they will have to review who the advisors are, what the advisors are doing, how much equity is paid and whatnot. So for me, that's a tick for ChatGPT. Well done. Clause 5 talks about the relationship of the parties. It says the advisor's relationship with the company will be that of an independent contractor and not of an employee. I like this provision because in our other video, we talked about the differences between an employee and an independent contractor, and it's important to specify that, hey, even though we have a relationship, I don't owe you CPF in the Singapore term. Let's look at the next clause. It says non-compete. The clause reads, during the term of this agreement and for X months thereafter, advisor agrees not to work for, advise, or otherwise assist any competitor of the company. So when it comes to non-competes, we have to be really careful because restrictive covenants are by default not enforceable unless they are reasonable. And what is reasonable varies depending on the situation and scenario. The second part of the clause talks about agreeing not to work for, advise, or assist any competitor of the company. Now, my question then is, if the advisor invests in a competitor, would that be a breach of this non-compete? It's not clear from this provision. I would also say that this provision isn't as tight as what I would typically see a non-compete provision as, because we typically would include words like not directly or indirectly engaged in a competitor. Why do we say these things? Because let's say Mr. Advisor has a wife. He can use his wife as the means to feed information or indirectly assist a competitor. So from that perspective, I would say that this clause is not complete. And this clause also kind of forgets that advisor can also establish a competitive company. And this clause is not tight enough, in my opinion, to prevent that from happening. The next few provisions are what I would say boilerplate provisions, so governing law and dispute resolution, entire agreement clause, and amendments. Now, what is missing from this agreement, I would say, is A, if you are issuing shares to your advisor, it does not have the lock-in provisions, i.e. telling your advisor, hey, you're not allowed to transfer your shares. And B, what happens if parties leave on bad terms, i.e. you fire the advisor and he has had his shares vested. This advisor agreement does not talk about your ability to buy those shares back or what price at which you can buy those shares back. Overall, in our past video, we said the NDA was pretty good. Now, this advisor agreement is not tight enough for me to be happy. So if I were a teacher, I'll give it 4 out of 10. And I would consider using something a bit more comprehensive if I can. Now, we hope you enjoyed this video and found this useful. And if there are any other agreements you want us to review on ChatGPT, let us know. Bye!